As designers, sometimes we have to deal with things that aren't quite as fun. So let's talk about some legal stuff. First off, copyright. Well, essentially, copyright is intellectual property. This means you're not making something that someone can touch. It's intangible creations of the human mind. These are intended to stimulate creative activity by giving creators of these intangible creations exclusive rights. These are usually time limited. In the United States, it's 70 years after the death of the author. Now, derivative work is work that is partially based on other copyrighted work. It must be different enough that the new material on its own would be copyrightable. This is where we kind of think of the idea of standing on the shoulders of giants, which is nobody creates something that's truly 100% original. Everything is to some degree derivative of someone else's work. Work for hire is when you are hired by a company, anything you create while on the clock will be copyrighted by the company. The company is the author, in other words. Since companies can live for hundreds of years, the protected term is 120 years after creation or 95 years after publication. The public domain essentially is intangible property that has no exclusive property rights assigned to it. These may have expired, been forfeited, waived, or otherwise been inapplicable. For instance, medical images that don't have any annotations on them are public domain. Works derived from the public domain can be copyrighted. So anytime you get paid to design or monetary value arises from your work, it is commercial use. And if you use someone else's work without permission, lawyers can see this as an opportunity to sue. Even if no money changes hands, you should get permission to use someone else's work. It's just that the exposure to legal action is lower. You can't get blood from a stone, as they say. In other words, if someone doesn't have money, you're not going to sue them and get money from them. Fair use prevents copyright from being too rigidly applied. Never assume you have fair use. Ultimately, it's the lawyers that make that decision. Fair use in America is limited by the purpose of the use, the amount of the original art that you're using, and the impact. If you're quoting someone else's book or using an image from someone's photo gallery, is that original author still going to be able to make money from their original work? If the answer is no, then it is limited impact, and so may fall under fair use. However, never assume you have fair use. Ultimately, it's the lawyers that decide. Similar to fair use in the Commonwealth of Nations, but it's limited to certain categories. For instance, research, review, reporting the news, parody and satire. This is not a worldwide concept. For instance, Japan does not acknowledge fair use or fair dealing at all. This is from an official McDonald's campaign. You'll notice that there's no trademark on the McDonald's logo. McDonald's actually wants anime to use their branding, so to get around the lack of fair use in Japan, they've decided not to sue anime that use the McDonald's restaurant concept. Now, not all of us have infinite resources and time to take our own photos, so we will generally use stock images in our work. Depending on the site, they have different purchasing options. Might be piecemeal, so you pay for each image like iStock, or all you can eat like Adobe. Creative Commons is licensing that's been developed by a nonprofit organization devoted to sharing and remixing ideas. They have created generous copyright licenses to facilitate derivative works. Anyone can choose to apply these licenses to make their own work freely available to others easily. Now, depending on the license, you may have to attribute who the original creator of the work is. So it could be just a small notice at the bottom of the page or on a acknowledgments page in a book. So just look at the terms of the license and make sure that you're following them. If you're taking photos of an object or a dog or a cat or a lion, you don't need to get a model release. A model release lets you use a model's name, image, likeness for agreed upon terms. In other words, money. Similar to a model release, it will allow you to shoot at a non-public location and use that footage in commercial works without further compensation. Now, these are liability waivers, so these make the lawyers happy. Basically, it says to lawyers, hey, this person agreed to have their photo taken. And we get it in writing, we have their signature. So all those things are covered. That is how you protect yourself. If you take a photo, you have the copyright. You don't necessarily have permission to publish it without the consent of the subjects of the photo. So permission to use a photo, it is separate from permission to use someone's face or a restricted location.